Hello, beautiful people. Welcome back. There's something called the Monell Standard when it comes to invoking any given rights, specific to 42 USC 1983. In the past, we've spoken about respondent superior, of how you can merge the entity along with the activities of the employee who immediately interface with you and, quote, violated your rights and trespass against your preserved rights, presuming you know it, and that you've actually set them up properly to be able to invoke it and to be able to use certain things as admissible evidence. The question now is, that doctrine of responde superior, can it be invoked when you do a 42 USC 1983? The past has shown the fact that it was not ratified and it doesn't exist. And even when you use 42 USC 1983, it cannot state a cause of action or right of action unless you pair it with a private right of action within the Bill of Rights. But nonetheless, here's another one that lets you know that you cannot invoke responde superior when you use 42 USC 983 for the same reason we've been going over as to why it does not exist and why it does you no good. Monell versus Department of SOC.SVCS.436U.S658, year 1978. This court case has not been overruled. Took place in the U.S. Supreme Court, the Appeals Division. Case number 75-1914. Decided June 6, 1978. Let's get straight to the point. On the other hand, the language and legislative history of subsection 1983, which is 42 USC 1983, compels the conclusion that Congress did not intend a local government to be held liable solely because it employs a tortfeasor. Meaning, even if you've proven reasonably that the one who is being employed, the employee, is a tortfeasor, and that evidence has been admitted that that man or woman is a tortfeasor, you still can't hold the entity or their employer liable if you're coming in under 42 USC 1983. Why? Because the intent and the language of the legislation does not compel them to hold anyone liable. They're selling snake oil to you with this whole 42 USC 1983. Now, all subsequent, quote, judge-made law tells you that. On the other hand, the language and legislative history of 1983 compels the conclusion that Congress, it compels, meaning it's a mandate, it's necessary, it's a force. The language of the legislative history of 1983, the legislative history of any given law tells you what the intent is. So the intent of the law behind the unratified 1983 compels the conclusion, meaning this is always the end goal, this is always the intent, that Congress did not intend a local government to be held liable solely because it employs a tortfeasor. Even though a lot of us know 14th Amendment is a corporate jurisdiction, they're now telling you even if it's in a corporate jurisdiction, it doesn't hold any corporation liable. They even broke it down to you in case it wasn't clear. In other words, a local government cannot be held liable under 1983 unresponded superior theory. Meaning you're going to have to bring something else superior as a right of claim to hold anyone liable vicariously or through the responde superior. There it is again, time and time and again. If this thing called 42 USC 1983 does not compel any corporate entity liable, what makes you think it's going to hold any man in their natural capacity liable? Think about that. In other words, here's a very unique way to think about it. See this 42 USC 1983? It is their form of hold harmless agreement, unbeknownst to people enforcing it. Again, that thing called 42 USC 1983 is a hold harmless agreement, whether you realize it or not. And they are telling it to you in many different ways that we've been showing. So now you're saying you want to hold them liable, and you're bringing a clause that says, here, I'm holding you harmless, so you owe me something. I'm holding you liable. Do you see how much sense that makes? And they're telling it to you in many different ways that we've been going over. Always remember, time is not owed to you. Life and energy is not owed to you. And these things that are being shared on a YouTube venue are being done so that you can do your due diligence to comprehend it. Because these are introduction. If you want someone else to show you more detail, you have to put value into it. If not, that's fine. Take care and best of luck.
Hey, and also don't forget to join my Patreon if you haven't. There I go through documents that I have used personally successfully and videos that I do not post here on YouTube that are in many ways private in nature. And also I go through live audio interactions and video interaction of my own experience with certain things. And I also have a website where you can go through a list of documents or services if you need them. And these videos that are posted on YouTube are also uploaded on Anchor. You can listen to it via audio means. And there's an Instagram page and a Facebook page. The link is on the screen and in the description. Take care and best of luck.